the only time the examining attorney ever found anything to be offensive in connection to the word slant was when they searched for slant plus the word derogatory plus the N-word. So obviously they were cherry picking those results. So we appealed using this very procedural and evidentiary-based argument system. Meanwhile, we decided to take a step back and ask questions of them. So for example, we said, hold on a second. If slant is this inherently racially disparaging term that you claim it is, how come you gave it to everybody else? You see, there have been over 800 applications for slant. Most of them were registered trademarks. None of them had ever been denied. I'm actually the only person in US history to be denied a trademark registration under this law. So we're like, how come all these other things like the slanted door, slant no rant, slant shack, slant records, all those are fine. But when it comes to the slants, you got a problem. Well, the government came back and they said, it's because you are too Asian to use the mark. Their exact phrase was, it is incontestable that the applicant is of Asian descent and part of an Asian band. Thus, there's an association with the disparaging term. You see, when they try and look at what could be a registered trademark, they look at the imagery that's supplied, logos, brochures, posters, and that kind of thing. We were applying for a trademark under the service category of live performances by a musical band. Our imagery was literally our faces, our ethnic identities. We couldn't change that unless I fired everybody in my band and replaced them with non-Asian people. Only then would it be acceptable to the government. So we said, you can't do that. And we continued to apply. We lost every single round of the way. Trademark Trials and Appeals Board, and eventually we get to the federal district in DC. What ended up happening is the main attorney had a medical emergency. So he was offline, like, you just ghosted me, like not answering his calls, not answering the emails. And I started talking to the junior associate, which I learned later on is the guy doing all the work anyways. I was the pro bono client, I get it. Well, the junior associate, Joel McMull, who's a friend of mine today, at the time he says, you know what, as a trademark attorney, you don't get a lot of practice writing constitutional arguments. So I'm just going to go ahead and throw some in here. He writes a very crude First Amendment argument that's like 2 or 3 pages long, and then a 5-page argument around the Fifth Amendment due process, saying that they can't use my race against me in order to make this rejection. We send all this into the trademark to the federal district, and we lose there unanimously in a 3-judge panel hearing because of an old ruling from 1981 called In re McGinley, which says, no, you actually, your First Amendment rights are not violated because you could still say anything you want. You just don't get the federally registered trademark. But 5 days after that ruling, before we even had a chance to discuss it, the court sent us what's called a sua sponte order to vacate. In other words, they basically said, oops, take it back, pretend that never happened. We're going to abandon that thing. And we want y'all to come back in and argue this thing en banc. All 12 federal judges up in here. But they said, we don't care about any of these other arguments. We don't care about the procedural issues. We don't care that they used your ethnicity against you. We only want to hear one thing. Does Section 2A of the Lanham Act violate the First Amendment? And there we argued yes. And 9 out of 12 federal judges agreed with us. They struck it down as unconstitutionally vague. They said it was viewpoint discrimination, that it was subject to strict scrutiny. Gone. But 6 months later, nothing happens. I don't have my registered trademark. That's because the government was filing suit to take me up to, that final boss stage of the Supreme Court. And there we made the argument. Again, it was limited to that one question, and they had locked the evidentiary record, so we couldn't even challenge them on the idea of using shoddy things like urbandictionary.com. We basically were limited to just what we had. But we made those arguments, and we won at the Supreme Court unanimously. So that's a quick nutshell version of almost a decade. would love to hear some of your questions and kind of provide more detail as I'm able to.
All right, if anybody has questions, feel free to jump in. I've got some to kick us off if everybody's a little bit shy at first, but you can either raise your hand or just unmute and start hitting with questions. All right, I'll go first.
Right. So
Go ahead, Norman.
Right. So in terms of questions, the one that I have first and foremost in my mind mostly has to do with like the constitutional argument that you guys ended up making like near the end that went up to the Supreme Court. What exactly was the argument the opposition was making during that Supreme Court case?
Oh, you mean what was the government saying?
Yes.
So the government's position was that the law was not unconstitutional at all. That they said they had a couple different arguments. I would say the strongest argument that they had was that that they said this was government speech. That a registered trademark is conveying a message from the U.S. government because they issue a certificate with a stamp on it that has a little seal, and they're like, you see, we don't want the government to be unintentionally conveying things that are racist or offensive to people. So like we because it has that government seal and it's sent to, like, you know, whenever they register a trademark, they send notifications around the world saying like, this is a federally registered trademark. They're like, we don't want to be supporting that kind of speech. So that was probably their strongest argument, except for the fact that they were federally registering all kinds of stuff. I mean, pornographic companies hold like tens of thousands of trademarks. So if we're talking about like what's the government standing behind, or even products that they probably shouldn't be determining in the marketplace, that point is kind of, you know, neutralized. Yeah. The other thing is they tried to kind of make comparisons to the copyright regime as well, saying like, well, we don't register every single thing as a copyright. Like it have to meet certain requirements. And they spent a lot of time like going back and forth on this, both at the federal circuit as well as the Supreme Court. But ultimately the judges and justices say like, this is a different type of thing. So they kind of struck that down pretty quickly as well.
All right. What was the name of the law again? It kind of got lost in the saga.
Oh, it's the Lanham Act. It's a 1946 law that kind of provides guidelines on what could be a registered trademark. And it more specifically, this is the disparagement provision of the Lanham Act. I should also mention that a year after our case was heard at the Supreme Court, there was another case that came up called In re Brunetti. And that case actually struck down the scandalous and immoral provisions of the same law. And that was for a clothing company, you know, FUCT. So the trademark office like, that's way too scandalous, which is funny because they issued plenty of registrations for French Connection UK, which is, you know, FC UK, but FUCT was too hot for them.
All right, one of the questions in the queue is we've got some younger law students just now jumping into the IP realm. Can you describe what your experience was with the TTAB hearings? Was it similar to a regular court federal hearing?
So TTAB, or Trademark Trials and Appeals Board, is really interesting in that there's no like physical court. It's just basically sending a bunch of documents and it's all kind of done online, or if you really want to go old school, you can physically send the documents and then they scan them in and they become PDFs. You know, it's interesting in that a lot of legal scholars kind of call the Trademark Trials and Appeals Board a bit of a kangaroo court because it's comprised of former trademark examiners, and they tend to basically agree with what the examining attorneys say. So the reason why we were actually trying to find a way to get out of it quickly is because we knew that they weren't gonna issue on a decision, especially if it's something that's under like the disparagement provision. the examining attorneys usually got to call up to their supervisors and say, hey, what do you think of this? Like it's usually out of the control of the examining attorney. So we knew we were going to lose there anyway. And we wanted to basically get to a point where we could get to the district level, and then the federal district oversees it's rather than a geographical district like the 9th district court or 4th district court. They oversee certain aspects of laws, and USPTO is one of the areas that they oversee. So that's why we ended up appealing there. But being in court is weird. It's like I will say that the federal district is interesting in that the building is huge. It's right across the street from the White House, and they got like balcony seating up in there. I mean, it fits a couple hundred people. So when our case is being argued, it was jam packed, especially with a lot of law classes who wanted to like see what it was like, because you know, it's pretty rare for things to be argued en banc. And so I actually ended up doing a lot of classroom visits when I was in DC at the time. The Supreme Court is a far more intimate. It only seats like 250 people, and it's it moves quick. I mean, it's like our arguments lasted for 55 minutes, and they could care less if I was in the room. Like it was not guaranteed for my band to be there, even though my name was literally on the case. But there was a lot of really cool, powerful moments being in the room. I really appreciated being able to be there to see what it was like.
Did your whole band get to sit in SCOTUS, or was it just you?
It was the whole band. I had to fight for that one. But we made it happen. And, you know, it's like I could sit anywhere near my attorneys. Like they're arguing from these tables up front, right below the raised dais where the justices sit. Behind them are rows and rows of padded chairs. Those rows, like 4 or 5 rows of seats, those are reserved for members of the court, like people who are able to practice in the Supreme Court. And behind them, there's the bar, and then there's all these pews. I was actually in the second row of all those pews. The first row remained empty the whole time. And what was funny is like when we came in there, like we got in early. Like we went through a side door of the Supreme Court, like it was TSA pre-check. And they brought us there very, very specifically. Once the room began filling up, though, it was mostly trademark law, First Amendment law geeks, a lot of law students and law professors. In fact, I knew a lot of the people that were in there. And, you know, they're seeing 4 Asian dudes up front in suits. So, of course, they're making that connection. And they're like, that's the band. And they make all this commotion. They actually asked for the court marshal to come over. And they're like, hey, this is Tam of the case being argued before the court today. Doesn't he at least get to sit in the front row of this? The marshal says, well, I got to check with the Solicitor General. And I was like, man, that's the dude we're arguing against today. I don't know about that. He leaves. 10 minutes later, he comes back and he looks at me and he says, I'm sorry, but we're saving the seat in case someone important shows up today. And I was like, you know, yo, why you gotta cut me down like that? But it was exactly how I felt throughout this whole process. They didn't care what I thought. They didn't care what my community thought, because they had almost a decade. And throughout that entire time period, time and time again, they told us that it was not necessary for them to speak to a single Asian about the issue, even though the issue at heart was what's offensive to Asian people. And think about it, even at the Supreme Court, it was all non-Asian people arguing about what's offensive to Asians. And the only Asians in the room were not allowed to say anything, even though it was a case about freedom of expression. And even at the federal district, the trademark office was trying to get one judge to recuse himself, the only Asian American judge there, Ronald Chang. And everyone's like, hey, you can't just tell him to step off because he's the only Asian up there. And they're like, no, it's because he used to work with the trademark office. We were trying to get him to recuse it, but they didn't ask any other of the judges who also specialize in IP law, who wrote law review articles about the same law, to recuse themselves. So it was just this really underlying thing. And it just shows that like how these decisions get made and how important it is to have representation, even in the highest levels of court, because sometimes people just don't understand that lens of what it's like.
I can't imagine what that must have felt like for you to just feel like pushed aside when it's your case. It's crazy.
Oh, it felt invisible. I guess I'll share this real quick. When the oral arguments started at the Supreme Court, it was just like, I felt like even though they're all using my name and they're using the name of my band, I felt like they were talking about someone else, because they were talking about this guy and this band who's doing really offensive things, who's derogatory to the community. And I was just like, y'all weren't there. Like, you weren't there as we were doing anti-racism work on behalf of the government, or how we worked in all these anti-bullying programs, how I counseled kids out of taking their own lives, how we would like do things that we spent all the profits from the band raising money to and spending it on research over to figure out racial disparities in the country, especially around like issues of medicine and education. And so I was like, you don't deserve to use my name. Like, I just felt totally insignificant. And it wasn't until about halfway in the arguments that this moment happened where this little voice pops up, and it's Ruth Bader Ginsburg. She says, wait, everyone knows the slants are Asian. They're not using the word to disparage, but to describe and to remove the sting from the term. I mean, I remember looking at my guitarist who's sitting next to me, and I was like, yo, I think I'm in love with a Supreme Court justice, like notorious RBG. She's throwing it down. Like, while everyone's talking about convoluted law, she brought it back to center. And like, I was already a fan, like I before I got there, but that moment was when for the first time, I felt seen, and I got it. I was like, this is why millions and millions of people treat her like a rock star, because they felt seen in her dissents. They felt seen in her writings. They felt seen in her just providing a shred of dignity to them in a way that the law wasn't. You know, when the law was just treating them as subjects, something to be argued against or whatever, she was seeing them as people. And I was like, she didn't have to say that, but it meant the world to me. I mean, that made me feel like, okay, I'm not crazy. Like, all the arguments I'm trying to make don't make sense in a legal brief. She's summed it up in a really quick way, and it just was so powerful.
I think that's especially important for us to hear as young lawyers, that we always need to remember how the client's feeling. That's a great point you made.
Well, the thing is, like, my attorneys, they meant well. Of course, they were generous. Pro bono for like half a decade. I mean, that's insane. But they also, whenever I talk to lawyers or even a lot of law professors throughout this process as I was going up, they were just like, it's okay. If they're wrong, you can just appeal. I'm like, appealing means another year of my life. Appealing means I know I have to like plan to spend $20,000 to $50,000 on LexisNexis fees and appellate printing and all this other stuff that I shouldn't have to be paying, that at the end of the day, even if I win, I don't get reimbursed for any of that stuff. Like, appealing means, in my case, I had to walk away from being a professional musician. My whole life dream, I had to walk away from that so that I could continue fighting this law. I had to take on all these side hustles and gigs just to pay the bills so that I can make it happen. And I think people forget what it's like because they just see the names on the cases, on the dockets, and they're like, oh yeah, they're doing something. And then people make the arguments as if those people didn't even exist.
It looks like we've got a question from Professor Gibson.
Thanks. Thanks, Mr. Tam. This has been a really, really interesting talk, and your case is so compelling because you were obviously, as Justice Ginsburg said, you're actually trying to sort of reclaim the term. You're not using it disparagingly. Like, it was really dumb to have the rejection at any level, and I'm glad the Supreme Court kind of vindicated your argument in the end. I think it's interesting that the ruling wasn't because you weren't using the term disparagingly, you can register it, right? The ruling was, we're taking disparagement out of the law, right? So that you cannot, so no one gets a trademark rejected after your case because it's disparaging, right? That's sort of the First Amendment holding. So I'm wondering if that worries you at all, right? Because people who actually aren't trying to reclaim terms and may actually be using a term disparagingly can now register trademarks, whereas they couldn't before. Like your victory wasn't sort of tied to the compelling aspect of your story. Your victory was broader than that in a way maybe you hadn't meant or anticipated, and just sort of how you feel about sort of the law that you've created that didn't necessarily correspond narrowly to the really compelling case that you've told us about today.
Of course, no, it was something that was definitely on my mind, and I think it took a lot of learning about trademark laws and how they work for me to be able to get it. For one thing, if our intention is actually to prevent people from, say, doing hateful things or saying hateful things, a trademark registration is like the most convoluted way of like trying to get them to stop doing so, because people can actually use marks. It doesn't preclude them from using the name of a business or a racist sports team or anything like that. It just prevents them from getting a federally registered trademark. So it doesn't actually, if that's our end goal, we aren't actually achieving it. The other thing is, like, people were already registering tons of really ridiculous, hateful, offensive kind of stuff anyway, because it was up to the individual examining attorney to determine if it's actually offensive or not. Like, as I mentioned before, slant itself was registered many, many times. In fact, every single racial slur that you could think of for an Asian American was a registered trademark. The only people ever rejected under 2A were me and this guy named Randall Liu out of Atlanta, who was making these t-shirts that said Chink Pride. And when we actually did surveys around 2A, it turns out that there was a disparate impact. Because if you think about it, like, who are the kinds of people that tend to reappropriate language? There would be, communities of color, members of the LGBTQ community. It turns out it actually makes them prime targets under this law, because, like the fact that I was considered too Asian to use my own mark, many of those people were considered too queer, too black, too, there were a lot of language around women kind of being reappropriating language that were being rejected for similar reasons, but they were giving these to private entities, larger corporations who had the funds to appeal, or porn companies over and over again. So at the end of the day, while I was a little bit more limited and reserved in my view of, like, the First Amendment, I came to understand and appreciate a more broad view of the First Amendment, and that, like, in order for ourselves to be protected, you got to protect the stuff you don't like. And you got to, that's part of, like, the First Amendment. The whole point of it is because the people who don't actually get to appeal tend to be those who are traditionally marginalized, who don't have the resources, who don't have a decade of their life to appeal all the way to the Supreme Court. And we kind of seen what happened. It's been, roughly 3 years. And what ended up happening is, like, almost immediately after my case was won, we had dozens of applications to apply, so-called disparaging terms at the USPTO. But it turns out all those applications were from artists of color and nonprofits and people who traditionally would have been rejected. So I think, while I'm not a fan of people using really offensive stuff, I'm probably less of a fan of the government wielding that power to decide, like, who gets to say what's acceptable, because chances are the administration might flip and it might be somebody else who might dislike your views, whereas, like, you never really know where it goes. So I kind of think of it as this philosopher John Rawls, who says that, the rules that are the most fair are those that we would all agree to, no matter who is in charge. And any application of a subjective interpretation, I think, is quite inequitable.
Great, thank you. Professor Kraft has a question.
Thanks, Lindsay. And thank you to Simon for being here. This has just been such a captivating talk, and I really appreciate your presence and willingness to share with us. My question is regarding your comments earlier about being, the the pro bono client. We have a center here, the Carrico Center at the law school, that is entirely devoted to pro bono service, and many matriculating students at the law school tout our commitment to pro bono service as being a major factor in their decision to attend the University of Richmond School of Law. So I was wondering if you could speak a little bit more to the impact of attorneys being willing to offer pro bono services, and how you think your journey might have differed if attorneys were unwilling or unable to offer those services.
I can say without a doubt that if it wasn't for the generosity of folks, you know, doing this pro bono, I wouldn't have made it. There's no, I mean, you know, if you look at how much it costs to litigate up to the Supreme Court, it's in excess of $1 million usually, between legal fees and court fees and everything else. I mean, it's unbelievable, like how much it costs. I had pro bono help and I almost lost my house because of the fees, you know? So to get, as you get higher up in the legal system, that need is even greater. In fact, when we got to the Supreme Court, I think I was able to do it mostly because the generosity of not only my own like law firm and the attorneys there, but also because of like 2 and 3Ls. So the UCLA School of Law, they have a First Amendment clinic, and their students actually did most of the research, and I hopped on the phone with them on many occasions to like talk about legal theories, and they were able to put it together. Unfortunately, they couldn't join us. I wish they could have at the Supreme Court, but I was able to visit their school later on and like meet with them and give them records and T-shirts and stuff like that. It's like what I could do to say thank you. But you know, the wild thing is, like, when I think about it, is like I spent almost a decade of my life, at the time, like almost a quarter of my life in court, and I didn't even commit a crime. There's a lot of other people out there who need help, who need representation. When you think about the kinds of clients that require pro bono help, they require it because they don't have the resources. They don't have the same voice that as others do in our society. So it is absolutely one of the most just and generous and compassionate things that you can do as a person, as a human being. It is so important because like so much of our lives are dependent on law. And so if you have a chance to get involved, I would highly encourage you to do so.
All right, next question in the queue is, what challenges did you face as a client trying to understand the legal system?
Well, for me, as I kind of mentioned earlier, I was like an unusually involved client. So like when I first started appealing, I was just like, I don't get it. Like, why can't they just do the right thing? Like, this doesn't make sense to me. And over the first couple of years, I read every single law review article ever published on 2A and on trademark law. I was like, I gotta go to school for this law, because if I'm gonna do something, I want to make sure I'm doing the right thing. And so I learned a lot about it, and it helped. But not everyone's able to do that. You know, like I mentioned how I had different representation initially. The first guy, Spencer Trowbridge, who was my first attorney, he was great. Like, he was the kind of guy that hopped on the phone all the time. I mean, this is like late 2000s. So if, I don't know, some of you might be too young to remember, but like T-Mobile used to have this plan where you get a top 5. And as long as you called one of those numbers in the 5, you had unlimited minutes. Spencer was in my top 5. I was calling him every single day. We would always kind of wrap up. I'd be like, okay, what if I talk to this senator? What if I talk to this organization? By the time I got to my second attorneys, Ron and Joel, it wasn't like that. I got an email every couple of weeks. And if I got on a phone, it was like a 10-minute call, because that was kind of about it until we were like towards the end, and I was really pushing. I was like, you can't file anything unless I review it first. I need to have my say on this. So it was a very different type of relationship. But and I was the one actually sending them law review articles. I was like, no, but look at this. Megan Carpenter calling bullshit on the Lanham Act. You got to read this article. Like, this is the argument. Like, so it was just, I felt like I had to be able to like stand up for myself. And yeah, the biggest problem probably biggest hurdle for me was like, I didn't have a legal background, like as far as law school goes. I was like in community and grassroots activism. So I just knew how to mobilize people and get those voices heard. And so I was just like, well, I got to do that for myself. And the other kind of big problem is just, or challenge would be just those court fees. I mean, this is just ridiculous. I'd never heard of appellate printing until I got a bill for like $6,000 for some copies and staples. I was like, this is stupid. I could do, why can't I just print these off myself? But that's the system, you know, that it's in many ways, whether it's intentional or not, it discourages people along the way.
All right, next question in the queue is about when you started collecting evidence from the Asian American community to help your case. How did you go about collecting that supporting evidence?
I mean, thankfully, we already had those relationships built. Like, as I mentioned, we were already touring and working with organizations. By the time I started to need to collect evidence, I already worked with 145 advocacy organizations across the country. So I was calling people up and you know, it's tough. It's a tough ask because I was asking underfunded, under-resourced nonprofits to take time out of their day to like file a legal brief. And I would do whatever I could to help them out. But that, you know, that also kind of limited the viability of that particular course of action. Thankfully, folks were very, very generous. And, you know, again, like that kind of pro bono help, many of them filed amicus briefs, which cost money to file, but they either did it or they joined onto other briefs. So I had like 7 organizations file and like sign on to the ACLU brief at the Supreme Court. Everyone from the Asian American Legal Defense and Education Fund to the Japanese American Citizens Alliance, and so on. Like they did it so they didn't have to pay the fee. And then other folks were really generous. I had 2 law professors, one out of Chicago, Kent, and one out of University of New York. They were the ones that conducted the survey. So yeah, it's like it takes a village to get a case up there. But a lot of it was just like me just hopping on the phone day after day. I would say for the last 4 years of the case, I probably spent an average of 20 to 30 hours a week doing outreach, collecting legal declarations, doing research, trying to get people to sign on. It was like I spent more time on my legal case than I did in the recording studio. Like band members will remember, like after we would go on tour, like we were still operating as a band. That's the wild thing, is like we still had a career to manage, but I would actually carry a suitcase full of law books with me and papers and documents. And every night after the show, like we would get 2 hotel rooms. And I made a rule. I was like, okay, 1 room is the room. You could be the party room. You could stay up. You could order pizzas. You could do whatever. And then you got to have the quiet room. If you want to sleep, you could sleep in here. But that's it. Because after the show, up until about 4 or 5 in the morning, I was studying law. I was sending out those requests. I was like pre-scheduling emails to go out and then doing follow-ups. So that's kind of what it took, at least from my perspective as a community activist. I was like, it's very, very important to get those voices heard. And something else I'll mention that I did, much to the chagrin of my attorneys, whenever I talked to an organization that didn't agree with us, that were kind of hesitant, that were afraid of the fallout, I was like, you should file a brief. And if not, you should sign on to this brief who's like totally against us. Because, you know, my attorney's like, why would you ever do that? I'm like, we're fighting for freedom of expression case. I'm not about to suppress other people's speech. Like that perspective needs to be heard too. If the Supreme Court's making these decisions, they got to consider all the different fallouts, all the different perspectives of my community. We're not a monolithic group. I'm not saying all Asians support us. Like they need to be heard. They have every right to be heard just as much as I do. So that was something else that I did. And I would oftentimes make recommendations and help them in their arguments against me. So that was kind of part of the fun of everything. And some people change their mind as a result. And they're like, you know what, after working through these issues, no, we see your point. And what's great is I've in that past few years, I went to many of these organizations afterwards, and almost every attorney that wrote an amicus brief against me said that they wish they had never done so. That they're like, no, after we actually hear your whole story, we realized that you're right, but we were only given a couple of weeks. We were assigned this task. We didn't really know what was going on. Now that we've heard it, they're like, you know, we wish we'd have done something different.
Does anyone else in the audience have a question you want to jump in with? Professor Scott?
Yeah, I have a question. Part of a comment, part of a question. One is channeling a little bit of what Professor Gibson said. I think it's interesting that because of the status of 2A disparagement being thrown out entirely, you know, teams, groups, including sports teams, could be filing for things. And you argued your case multiple times in the city of the Washington Redskins. But then it's sort of like the court of public opinion has kind of influenced them to be just the Washington football team for this year, and they're moving away from it, which I think is really remarkable. So, hey, I think that it's interesting that you sort of opened up the law, that they could have pursued it, but then, you know, people's sort of consciousness is also open to move away from that. So that's good. But my question is about the Slants Foundation. Like, what have you found that you've done to sort of give back to the community? And I saw that you started a foundation. And what kinds of other things do you think you're able to do that you might not have been connected to or might not have had the resources to do prior to some of the activism, or maybe throughout the evolution of your activism?
I think the nonprofit we started was the inevitable next step for us. You know, to be honest with you, like, most bans don't last that long. By the time 2017 hit, which was the year we had our case resolved, I'd already been doing this band for 11 years. And I knew it was kind of at the end of its life cycle. In fact, in a lot of ways, I wanted to give up on the band years before, but I knew that I had to keep it going for the case. So we just kind of realized, and last fall, we made the decision to retire from touring as a full rock and roll band, and so that we could focus on our advocacy work more. And so we started this foundation because we saw this huge gap in how arts funding works. Like, it's traditionally a very inequitable process. Like, the people who need the money the most usually don't get it, and the people who do get the money usually spend more time trying to file reports on grant deliverables than they are working on their craft. We're like, why not fund the people you believe in? And so we want to kind of show that it was possible to change the system, to change the model in which arts grants operated in. And we wanted to pair it up with mentorship. So we focused on funding artists that have a tie with community-based activism, who are incorporating it into their work, so there's some accountability. And then we also provide mentorship along the way. So far, we've funded a little bit over a dozen projects in the last year, and everything from films to dance projects to musicians putting out albums. And it's been a really, really fascinating process, but it's been incredibly rewarding. This year, as COVID started hitting, we noticed there were actually two epidemics, right? We had the pandemic of the coronavirus, and then we had this pandemic of racism. This huge rise in anti-Asian racism. We also saw a sharp decline in arts funding as people were shifting their priorities. So we thought, why don't we speak to that? And so we decided to fund works of art that was speaking to anti-Asian racism, but we're doing it in a way that didn't kind of stoke anger, but instead asked provocative questions that would compel compassion and empathy and engagement. And so we were able to help artists throughout the COVID crisis by doing just that. And so a lot of it's learning. I mean, it's 100% volunteer driven. Most of the profits from my book and our album sales of the past year have funded this thing. And I think we're still evolving. I think we're still learning. So you know, that's one of those kinds of things. You kind of mentioned at the outset the comment about the Washington football team, and I think it's analogous in the way that sometimes things don't work out the way you think, but as long as you get there, you just keep working on the steps through persistence. And what's funny about that is actually behind the scenes, we're helping the attorneys who were representing Native American communities throughout the process. I was giving them information about judges, what could help them out. And I was working with one of the co-founders of the Not Your Mascot movement over the last 3 years on like how we could shift power to affected communities. And one of the legal strategies, or one of the strategies used to eventually get the team name to change, which we knew didn't happen via the trademark office, wasn't actually just because of those companies deciding of their own volition out of goodwill. It was a long-term battle. We actually got Native American activists to buy stocks in Nike and in FedEx so that they could attend shareholder meetings. So they could say, hey, if you want this money, y'all got to pull funding from these racist football teams. And because of that, those companies made a public announcement, and it just so happened because of George Floyd, because of so many of the tensions that were being felt in this country were kind of breaking loose, that those companies realized it was time to do that. So there's a lot of different levers being pulled in order to create a difference. And I just like thinking about like how do we work arts funding or how to remove mascots or anything else. I have encouraged folks like use creativity. Think like, what are some of those underutilized channels? If you just work in law, like your tendency is just think in law all the time, but sometimes it helps to team up with some activists who just like, go all out in all kinds of other ways to make it happen.
And I think along that aspect, the next question in the queue is, do you plan on working toward having legislature codify a law that maybe reflects these new opinions?
I think, when it comes to trademark law, the thing is like, I think there's a lot of reform happening at the trademark office right now, like just thinking about procedurally how it's kind of an inequitable process. But I think I'm glad to see what happened since, with my case and Brunetti, because it's more in line with the other areas of IP law and patent and copyright law. Like you're not making these moral and ethical interpretations of like the content of what something is. It's like, as long as people meet the requirements, it's a very procedural kind of thing. Like if you can prove you have secondary meaning, like that, you can't just register something offensive just because you think it's funny or cool. Like you have to prove it's a unique product service identifier. So like there's these kind of systems already in place to discourage kind of nefarious activity. I think we just need to continue to hone that process. I think that I don't think new legislation needs to be passed. But if Congress could find a way to pass a law around this, around speech and language, which we know evolves, both intention and meaning are required, both context is required, and it still allows for things like irony, satire, and wit to exist so that they can neutralize hate. If they can do that, then good luck, go for it. I think it's very, very hard to find a way to create a law that encapsulates all of that, and both on terms of the like policy end as well as the enforcement end. But like maybe people are much smarter and compassionate and able to do this better than I could.
All right, and then we will wrap up with this last question. Do you think, are you done with dabbling in the law? Are you burnt out?
Oh, I am like super burnt out, but I don't think I'm done. Even last year, I filed 2 briefs at the Supreme Court. One was in the Brunetti case, signing out an amicus brief. Another was working with a number of rappers like Killer Mike, Chance the Rapper, Meek Mill, and a professor actually at your university, Eric Nelson, over this case on Jamal Knox versus the Commonwealth of Pennsylvania. So we saw that people were using rap lyrics to criminalize individuals in ways that they weren't doing with, say, any other genre of music. And of course, this falls along racial lines. So we were filing a brief at the Supreme Court to review a case. Unfortunately, we didn't take it up. But yeah, I feel like law is one of the many levers that an activist has at their disposal. And if and when I can be of use in that arena, I'm happy to do that. If it's more about making noise and keeping folks accountable, I'm happy to do that as well. For me, it's more about thinking of that end result. Like, how do we bend the moral arc of the universe towards justice a bit more, right? So if it's going to be law, like, yeah, but don't expect me to show up at any law school for classes because I'm done with homework.
Well, thank you so much for coming to speak with us. This has been so inspiring to hear all your work and you wanting to help and dig into the legal community as a client. That's great to hear. I just want to say on behalf of APALSA, SIPLA, and University of Richmond, thank you so much for giving your time to us today.
Thank you so much for your time. And thank you all of you for choosing this career path, because it does make a difference for so many around the world, including myself. I am always in just deep gratitude over those who choose this path, because I know it ain't easy, but it does make a tremendous difference in for people like me and for generations to come. So thank you.